the views of both the Government of British Columbia and the Government of Canada. In the time available today, it is not possible to address all the issues raised by this petition. Canada therefore continues to rely on all its written submissions. The petition brought by the Hulquminum Treaty Group raises issues that implicate negotiations under the BC Treaty Commission in Canada. This petition, which examines the rights of the HTG under the American Declaration on the Rights and Duties of Man, also affects the interests of many other First Nations and many non-Indigenous persons in British Columbia. This petition raises issues of great importance to all Canadians, the reconciliation of Indigenous rights with the sovereignty of the Canadian state. In essence, the HTG alleges that Canada must demarcate the land contained in its claim to ancestral territory, and that it should have done so long ago. All other allegations of the petitioner flow from this central issue. Canada takes issue with all aspects of the petition. A key element of its defense, however, is the large gap between what the HTG claim is their property or ancestral territory on the one hand, and on the other hand, what in fact are the property rights of the HTG. In its submission dated October 12, 2011, Canada noted that the member First Nations have reserve lands, which are set aside for their sole use and benefit. In the time since Canada joined the Organization of American States, there have been no takings of land from the HTG or any of their member First Nations. The HTG assert a large portion of land taken up in the 1880s is their ancestral territory. This claim to ancestral territory exists as a basis for negotiations under the BC Treaty process, as it was identified by the HTG in their Statement of Intent, which is part of that process in the early stages. This claim has also been asserted before the Commission in this petition. This claim has never been proven. It has never been subjected to a determination of all treaty negotiations within the BC Treaty process, and indeed land claims in other parts of Canada potentially. Canada affirms the strong will of both the Government of British Columbia and the Canadian Government to continue striving with the HTG for a settlement of their claims through the BC Treaty process. Canada remains optimistic that a comprehensive settlement can be achieved. Canada asks the Commission to find that Canada has not violated the rights of the HTG to property, to cultural rights, to freedom of religion, to equality, or due process as protected under the American Declaration.
Of the domestic treaties, as you call them, in Canadian law, can they be changed by subsequent state or federal legislation, or are they of constitutional rank? In other words, what guarantees are there for the future if these domestic treaties are signed? And I say that as someone who's looked at the consequences of U.S. treaties with Native Americans. Secondly, a number of other common law jurisdictions have recently revised, or the courts have rethought some of the traditional doctrines about native title, and I think particularly of Australia and the Mabo decision. And I'm wondering whether the courts in Canada have similarly sort of re-looked at the idea of original acquisitions or early claims over Indigenous lands in the way that the court did in the Mabo decision. Thirdly, you made a mention that the government has not collected or tried to collect as yet any of the loans that have been made for this process, and I'm wondering if that is a policy of non-collection or if that is simply a deferral to a later time of making a decision on that part. In respect of the kinds of financial assistance that you mentioned, I think you said $54 million, do you view that as a form of reparations, or is that just simply a part of the government policy generally? So those are my questions. I'll ask the country rapporteur if he has any. Aren't you the country? No, you're the country rapporteur. Yes.
Sí, gracias. Yes, thank you, President. I'm grateful for the respective presentations of both parties, and notwithstanding that I will be studying carefully all of the information that's been submitted in writing and that will be submitted in writing for the report of the merits in this matter, I'd like to take this occasion to put a couple of questions to each of the parties. And evidently, well, you could answer right now and or in written submissions subsequently. First, I ask the state, do you consider that there's a legal difference between the concept of private property and ancestral property of indigenous peoples? And in the event that you consider that there is a difference, would you consider that the ancestral lands of indigenous peoples in general, which may be alienated without consulting the peoples who live there, would continue to be ancestral lands which could prevail over those who hold private title to the land? And for the petitioners as well, I would ask you whether, as of the 1990s, what activities did you continue to carry out in the territory that you consider to be occupied by third parties, and with what frequency were such activities carried out? And while you already mentioned some aspects, how do you consider that the alienation of your presumably ancestral lands have impacted your cultural integrity? Thank you. Thank you very much. I am going to ask a series of questions, both to the state, which are for both the state and the petitioners. The first question is whether in Canada the law recognizes property rights of indigenous peoples to their ancestral territories as a category of its own, or is it considered to be some other form of private property? Second question is, I'd ask that you inform us as to what actions and procedures exist in the Canadian judicial system to resolve land claims by indigenous peoples and economic reparations. I would also ask the petitioners whether such actions have been brought within the judicial system and whether you consider that such actions are adequate and suitable for respecting your rights. Thank you very much.
Thank you. Before I give an opportunity to both sides to reply, I'd just like to make an offer. Next week, the Commission will preside over the signing of a friendly settlement on a major indigenous land claim involving another of the member states. And we expect that will be followed by yet another. So it is something that we are very interested in facilitating. If there's at any point in the discussions between the group and the government that you think that the Commission could play a constructive role, we certainly offer ourselves to participate in the negotiation process to try to facilitate some resolution of this. I think our experience thus far has been, at least in this past year and a half, has been very positive in that regard.